Asia? Okay, Chair. We're going to call the East Lansing City Charter Review Committee to order on Thursday, January 23rd, 2025. We have here Asia as our staff person. We have Mr. Bellman, and we have sitting in here tonight for our city attorney, normally here, Tony Chavez, George Conte. Would you go ahead and call the roll?
Yeah, Diane Gutierrez,
Present.
Justin Payne,
Here.
Jonathan Foreman,
Present.
Dr. Ruben Martinez,
Here.
Bill Rhodey,
Here.
Sam Wild,
Here.
Dr. Veronica Wilkinson Johnson,
Present.
Dale Rudolph,
Yeah.
Lynn Richardson,
Here. So we have everybody here, so that's great. We're going to move on to approval of the agenda. I'll move approval with the addition of 2.3, and that would be communication from committee members. Is there a second?
Second.
Moved by Gutierrez, seconded by Hank. Any other additions? All those in favor say aye. Aye. Opposed, same sign. The agenda is approved. Then we'll go on to 1.3, approval of the minutes. I'll move approval of the minutes with one slight change. Under communications, the last paragraph where you said, depending on the resolution of House Bill 5700, I would like to add, it was determined that House Bill 5700 did not pass, so no further changes needed. That change, is there a second? Second. Moved by Gutierrez, seconded by Wilkerson Johnson. Any other changes? Okay, all in favor say aye. Aye. Same sign. Okay, moving right along. Written communication. We have the communication packet. Thank you, Asia, for putting all that together. We'll move on to 2.2, communication from audience. Nobody's jumping up to the microphone, so we'll move on to 2.3, communications from committee members. Does anyone have anything that they're bringing forward?
Charity. So I met with Mark Grabner, our county commissioner, along with Pam after our last meeting to review section chapter 8 and the transparency language that we put together. And Mark's one of our county commissioners, is also kind of recognized as statewide expert on FOIA, Freedom of Information Act, and he had a few suggestions. Thank you for that. So I'm hoping to get some draft language from him or Bitcoin straight to the committee. And that's it. So that's all we can present that. But not too much else to say about it, but I want everybody to know. Mark was also on the last part of the review committee. We did this before, so I'm going to try to invite him to come to talk more about that before we take action on that.
Hey, everybody.
I talked to a number of people and I'll hold my comments till we get to 8-1.
Okay, and I will just let you know, Mark had approached me about having the finance department present something about the income tax, since that's what we're talking about in the charter. And originally we tried to schedule it for this, but the finance department asked for a little more time, so that'll be on the agenda next meeting for February, where they're going to do their presentation. Sorry, Jill, you'll miss it, but I think you know that very well. With your expertise. So that's all I have on that. So we'll move on to new business. Chapter 11, general taxation is our first item tonight. And as Jill warned us, he said pretty much everything is standard, but let's just talk and see if anybody has anything that they'd like to bring. And we'll keep chapter 11 on for next week as old business, Asia, just because we're going to have the staff here. So we'll make sure everything's complete. So go ahead, Jill.
Well, are the assessors here, do you think?
Good evening. Some new faces to me in the room, so I'll introduce myself. I'm Dave Lee. I'm the city assessor. So in reviewing chapter 11, almost everything that we do is governed by state law. So what we've done and proposed and passed on to you guys is just some minor word changes here and there that seem to make sense. Nothing major. here to answer any questions you might have.
Changes, was that the comments? You had proposed changes, did you see those?
Yeah, they are attached on the agenda.
Okay, so when I look at the charter review comments, is that the?
So if you go under chapter 11, it's
Yeah, it's charter review.
Oh, okay, good. So that answered what my charter review comments. So that the modifications, to the charter review comments came from.
Yes.
no.
Okay. So you're gonna stay in case you have any questions?
Yes.
Okay, so do we want to go right away to 11.1?
11.1, if I may. I wondered when you look at the second line where it says the city may assess, levy, and collect taxes, rent, tolls, and excises, whether or not we should include fees in that list, because we charge fees. But it's not specifically listed.
So I'm going to turn to you. Do you think we have the ability to do that even though it's not listed in the charter?
Fees separate from taxation. So
That would be my, I think fees or fee income is an item that's separate and distinct from taxation. For example, building department fees or application fees or any other similar fees. Those are probably prescribed by other sections of, if not in the charter or by municipal.
If I just may follow up, what about rents? Would that not be the same? I mean, rents are not taxation. I know, excise would probably be a form of taxation.
Yes, excises would.
And taxes, but I didn't know if rents and tolls fall into that too. That's the reason why I'm not sure.
I think I can go back and we can confirm the right bestowed upon home rule cities under the General Property Tax Act and just confirm, because it's more appropriate to just, to the extent you mirror the language as opposed to add additional language, because we don't want to run afoul of our friends just, across the city border in the next town to tell us what we're doing. I can confirm that.
I guess I have a clarifying question, which is how does the city, what's the authority for the city to collect fees at the moment? If it's not in the charter, surely if the city is collecting fees.
Through ordinances.
Okay, so I guess what I would have concerns about from a city standpoint is if there's a ballot initiative to say the city may assess fees, then the ballot initiative is voted down, then all of a sudden can the city still collect those fees because people have clearly determined that the city can't collect. So I would just be a little concerned about that. If the city is on good footing right now, I don't know why there would be any change. Yeah, exactly, essentially. If the city feels it's on good footing right now, I don't know one way or another what the legal aspect of it is.
A lot of times there are different statutes, authorize the collection. As well. State statutes. If you include a fee in the tax section, that's an issue.
So I see, Dave, that you have in here something about if the city council chooses to
Yeah, this came from the finance department, not from Dave specifically. So these are suggestions from the overall finance staff. I'm looking at the income tax because of how it's being allocated, that there kind of be a relief valve that once certain things got by certain standards, that the money could be shifted to other purposes than what's currently spelled out in the chart.
So then my question again, then would be to you, George, if we pass ballot language to change the charter, and we're going to propose, if we're looking at, well, what, down the line, it's gonna be in 2030 when it comes, and we don't know where they're gonna be at, but we're just having some possibilities here. Wouldn't we have to have those approved? Wouldn't city council have to go back and change the charter then when they put it on the ballot, or versus us doing it as a charter amendment, because as a charter committee recommending it to them now, 5 years before it's ready to go?
As I read 11.1, the reference to it's any income tax that's authorized by this section. We don't impose an income tax. There's a 1% income tax or whatever the percentage is. It's just like, okay. Then, okay, so,
And the voters voted knowing where that income tax was going to be allocated
right,
to initially.
So it's,
What
specifically how to
Okay.
allocate funding.
yeah, unless it's voted on again or approved again. I mean, even if you make changes to the charter now, it still has to be a question that has to be considered in 2030.
So then this would, that the finance department was talking about the allocations.
Right, so they were saying if this is put on to add some language that said if we achieved, I believe it was a certain funding level, 85% it would, go 40% would go to pension, and then 30 would go to police and fire, and 30 infrastructure instead of the current formula of 60.
Wasn't there those percentages on the bill?
Yeah. That's what I.
It's just that
The
come
operation is.
2030, it's going to have to be voted on, whether it's amended or not. Well, whatever condition 11.1 is in 2030 is going to have to be submitted to the electors.
Veronica,
I just wondered, the word excise, is that only for income? Or are there other things out there? Is there anything else that would reference?
So when you look it up, excise tax could be on products produced. I don't know if the state authorizes local governments to use it in that way.
Yeah, just, I'd urge that at this point in time that we would not proceed to try to alter this. I think it's important to remember that it took us 2 tries to get the income tax in. And during the first try, by resolution, the city council established the 60% and 20% and 20% formula that we have right now. That wasn't good enough for the public. So when we came back the following May, we added it to the charter so that people would know this is insured and we couldn't change a resolution later to move this money in a different direction. We have not achieved the percentages that we were hoping to have even at this point in time because of, downturns in the economy and COVID and everything else that has happened over this time frame. I think that it's a good idea going forward if we do achieve our percentages that we were shooting for with regard to the pension, the unfunded liability that's out there, for us to take a look at this, but I'm not thinking that right now is the time. When we go back to the public, if we decide we're trying to extend the income tax, that's the point in time where we should put something on the ballot to change the percentages. It would be great to have more money going towards parks and recreation, going towards infrastructure improvements and things like that. But the thing that puts us on the edge of bankruptcy is the unfunded liability that we've had in the past. So that's why 60% of that money is going to that. And I think excise, for the record, includes any kind of taxes that we might, assess. It's sort of the broad term that allows us to do that.
all right, so that's 11.1, just leaving it where it is right now. Then going on to the further one is 11.6, the last assessment role of the city to record of the assessor. is the potential change? Can you speak to that? Okay. 1.6, the last line.
So the ownership of property changes throughout the year. And it seemed to me that having the reference made to the records of the assessor would reflect that as opposed to making back to last year's assessment roll or tax roll, which could be different and not current. It seemed like that minor change was warranted.
Currently, we're using the legacy list that is not the most current.
Current practice, no, we're not.
So current
Current
practice,
practice, this is not, yeah, so what we do currently is not according to charter.
right, so this is
Yes,
reflecting the current practice.
yes, which we think kind of has to happen.
Yeah,
Yeah.
yeah.
If that makes sense. So yes, we're in violation of the charter. I'm sorry.
As long as you come and
Yeah.
accomplish demands by a change.
I think that's a really important catch because as somebody who's just bought some property, trying to get the old people off, the old address off that BNA website that's been trying to get yours on there so you can pay the taxes. It's a good catch. Everybody okay with that? Okay, then.
And actually, state law specifies or states that the failure of any new property tax or any taxpayer to receive a notice of a reassessment in February when they're issued does not invalidate the assessment. That's specific in the general property tax. So that's what Dave is suggesting is wise.
All right, so then we'll see 11.6 was changed for next time. 11.7, Board of Review. I just will say, any of you have ever have the interest of sitting in on the Board of review of a taxpayer coming to see Board of Review and going through why they think they're taxed too high. It's a very interesting the board members are very attuned to what's going on, and it's a very structured way of looking at the assessment, but also very fair to the resident that's coming before them. So that'll be in March. So if you just want to have an idea of how that works, I don't know if you have the dates yet that people can show up.
The top of my head, I believe it's March 10th and 11th.
The Board of Review is the one commission, one board, sorry, that doesn't have any term limits. And it's my perspective in seeing those people stay on there, they gain a lot of expertise doing that, understanding the property. So that's why it's important not to limit that there. But that is the only one that is like that. Okay, 11.8. Got a suggested change here, unless otherwise provided by state law. So the board shall convene on the Tuesday next following the first Monday in March of each year.
Sure. So again, the General Property Tax Act specifies the dates and times that the Board of Review must meet in March to hear assessment appeals. And it just seemed to me that the language that's suggested would make it clear this is all governed by state law, and it would clear it up a little bit, make it, I guess, more simple for everyone.
Okay. Ready?
So are you removing first Monday? Suggesting removal of first Monday?
No, the Board of Review under the General Property Tax Act meets on the first Monday in March to receive the assessment roll. Or the Tuesday following the first Monday. And then they meet the following week on the Monday and for a specified number of hours during that week to hear appeals.
Thank you.
Yeah, so really no changes. It's just practice, and we, we're governed by the state law, and so seems to me that's how we should reflect it in the charter. That helps.
Make it clear it's not an arbitrary or just something
Right.
you guys came up with.
Right.
So next. Are you adding that last sentence? Is that what you,
Yes,
okay. Just for clarification.
yes.
Thank you. Oh,
Okay.
thank you.
Well, that's fine.
Okay.
Yeah, I really like that because I want this to, for Joe Q public to be able to read it.
And understand.
it, and make sense of it, yeah.
Yes.
Everybody okay with that? Okay, then George, 11.8. Come back to it. Okay? Sorry, not 11.8, we'll come back modified.
Okay, yep, got it.
Then I guess we'll go on to the next page, which is 11.13 through 11.21. See anything on this page here? Anybody have any concerns about any of this?
I had to assume this was all written. It would be, you know, I don't know. You know, I assume this was written and reviewed at the time it was created. And we're not hearing issues.
Okay, then I guess we'll move on to chapter 12. General finance borrowing power. Any concerns about this? Jill, you looked through this, you saw this is just the basic matter. Mark, you saw this is just we just follow the rules.
That's it.
Yeah, that's all prescribed from outside.
That's what I remember. All right, we can get through 12 really fast, no changes. And I know on our thing to the public, we didn't have chapter 13 on, so we'll put that on next time. But if we get through 13 and we don't have any changes, we'll just mention that and see if there's anything else for that, because that's supposed to be the next week. But we're doing really well here, so let's just go ahead and do it since it was on the agenda. That came out. So special assessments. I think what has occurred this past year at council, if I may, Mark, is really kind of applies a lot to the 13.15, the partial payments, and I guess 13.12 if you have ejections, and then 13.15 the partial payments. And council has that authority under the charter to change that, and they have changed that. The Chesterfield sidewalks this past year, or I guess almost 2 years ago, they were put out there, and some people had some major sidewalks repairs there. And so they created their own payment plan. I know when we annexed the northern tier, a lot of them were weren't hooked up to the city's water and sewer. And we made a decision at some point in time that we were going to hook them up. And we had the public hearings and everything and the assessments. And again, gave them some options of how they could pay over time or that, but there would be a lien on their property. And some people didn't want to hook up, but once that sewer line was there, rather than having a septic tank, they were having that sewer line. And anecdotally, the person that complained the most, that showed up at my house crying in the rain, showed up at council, came in on the last day and paid it all in cash. So, so it was like cutting to my heart, this huge assessment, and then showed up with cash on the last day. So it's an interesting life to be on the other side and have to collect the fees and make the rules and try to do something. But that's why we now have our water and sewer going up West Road and over to Coleman, so that development could occur along that corridor to bring more building and taxes into the city. So anything else you want to add to that, Mark?
No, there was a decision that, it was sort of like, field of dreams. We decided we were extending sewer and water north. And someday we hope to have that property, and we ultimately did. So it was, it paid off in the long run, but we made an investment based on an anticipation for the future. And it was the right decision for the city.
Yeah, the credit union went up there, all those,
All that's,
still didn't, they will come, so.
On a less positive note, we have a surface water management problem. And I'm wondering where, I know we're doing research on the flooding and that sort of thing. I would expect some kind of an infrastructure bond or something, some way to address this concern. I'm assuming it's in here somewhere.
I think it's in the ordinances for water retention, every proposal or a site plan proposal has to have all of those requirements that are met, plus water runoff and all of that.
But this is an existing, no, so we had a flood that was because we got so much water so quickly that the surface water structure couldn't handle it and it backed up. So we clearly need to enhance our surface water handling capabilities.
So, yes,
And what,
just simply in our annual capital improvement plan, we identify improvements to the stormwater system. And we have a 5-year capital plan that calls all of that out.
so it's just.
We're in the process of doing, I think, a drain off of Grand River this year, Oak Street, that area. Taylor Drain, I believe it is, that we're going to enlarge and address.
Okay,
It's all the ability to pay and the pace of those projects.
and that's a citywide, not an assessed, specific
Yes.
properties in a zone.
Well, a lot of storm water is charged through storage rates.
Sure, yeah, as
So,
is.
yeah, so
And so we-
citywide, yes.
So it's looking
So it'd
like
be-
it can be addressed by, capital improvement budget as
Right.
opposed to having to go out and do a bond,
We bond out, so we're gonna bond out through the state revolving fund.
regular
To do it.
capital improvement.
Yes.
Yeah, so, but no assessments, you don't expect
No
to do
assessments.
assessments. Okay, that's,
The rate.
not that I would be against it, if we need them, we need them.
You're saying the rates will go up.
The council
Rates will go
has
up.
recognized the problem. And the anticipation is that because of global warming, we're going to see more of these big rain events and other events that we have to deal with. And at this point in time, probably our stormwater drainage system needs to be expanded. And so that's over a period of time. I think that there's no plan at this point in time, but there's a study that's being done.
So right now, 13 stands, no changes to that. Like there anything else? We can go on to old business. 4.1 is continued discussion of section 6.6. This is review of the code. And I know at our last meeting, thanks to my researcher, who has a friend who's a researcher, who found that the Centennial, you all corrected me last time, so I've got it right, the Centennial review of the code. I'm gonna have Asia send you the link. You've got in front of you the memo from the city attorney at that time, Tom Ewing. There are, I believe, 10 pages in this link where each department has went through the code and put what they thought needed to be done and the city attorney's review of that. So rather than print it all out or just because I was trying to come over to seeing the extra 10 pages, well, look at that, and then if we have any questions at the next meeting too about that. But I'll turn it over to you on what.
So the February 4th meeting, the city council will be a resolution on their agenda to start the review of this 10-year review process of our code ordinance. So as you know, this was done in 2013, so we should have done it in 2023, but that's when the city was in transition. So I would talk to the mayor, we're gonna put a resolution on to direct the city manager to start that process. Much like they did back in 2013.
And I think you'll find it interesting to see how it did. And then if there's any changes next time that you want to look at it, we'll keep the 6.6 on there just to review the code and see if that met everybody's needs for how it should be done and if it's getting done. So
Were there public meetings?
Well, the internal review was not public. But when it went to the attorney and brought it to city council, yes, because they have to
Once
have
again,
two
once-
hearings
once again.
because they have to amend the ordinances. So yes,
Robert, how long do you anticipate the review?
I wish I,
Review?
that's a great question. I'd have to go look at it and see if there's any record of how long it took them. So when the first resolution was adopted directing the work to be done, and then the work that came out in August, I don't know how long that time.
I would not, I'd take the time needed.
Yes, we'll be thorough
Right.
and not rush it.
Right.
But
Because I
we'll
don't,
undertake.
even though it's a little late, it's not real late and,
Oh, yeah, I wasn't suggesting rush, I was
No.
keeping so long.
Yeah. Understood.
Okay, so that one will be on so that you have a reaction to that. So then moving down to 4.2, which is, section 7.6. And really the rest of that, that's sort of where we ended that at the meeting at the end of last year. I believe we're close to the end of last year, maybe it was right before Thanksgiving. And we were going late to stop, but we didn't finish the rest of 7, which we did have, we did have a resident come and talk to us about the nepotism, and we never discussed that comment in that section. So let's start first with 7.6, where we're at on that. And I believe we were talking about the different things that we were going to have in 7.6. Which 7.6A, we talked about shall be a copy of these opinions loosely formed. The last 3 lines. Are we going to change that? Wanting to change that? City Hall, City Library, do we want a copy of those opinions on the website? We didn't add that. Is that something that we're just keeping in-house?
So you're talking about legal opinions?
These, the formal opinion.
Yeah, so the formal opinions, should probably ask Tony to define what's formal, what's informal.
But George will answer.
So any opinion written by the city attorney or city council is not something that will be made available to the public to review. Because state law says that it is a privileged communication and only city council can release that privilege.
Yes, certain opinions rendered by council to city council that are for an enumerated purpose are specifically exempt from disclosure under the Freedom of Information Act. And if you were obviously to make those available, the attorney-client privilege would be lost if members of the public were entitled to have access to that. But that being said, if there was a question that a department had requested regarding a legal opinion in terms of the position the city takes with respect to item A through Z, those would definitely be available. Have we done that as a matter of course?
We have
Robert?
We have not.
I don't understand that distinction. The distinction is the request or the.
It's the content. If they're asking a legal opinion on issues, for example, litigation or the purchase of real property. Those are 2 of the items that come to mind, or negotiating tactics in connection with the negotiation of a substantial project. Those things, your ability to retain attorney work product and or the confidentiality would be lost if they were made available to the public.
Sure.
But if someone were to say, if someone from DPW said, what is the effect of, what does this easement do? We could certainly write an opinion that says, this is what the easement does, and this is what all easements do, and that could be available in the library.
So this term formal opinion, is that a meaningful term? Is there informal opinions? Is there,
So I look at an informal opinion as when he sits in a meeting and gives us advice. That's.
but in this case, we'd like to identify the ones that fit the public document, like the ones that aren't attorney-client privilege protected. See what I'm saying? So,
Yeah, of course.
So if we could have some wording that whatever type is a definable data type of opinion, oh, that's this sort of opinion, that's just gonna go up on the website, or the meeting code or whatever.
So Mark, help me, would an example be what he felt the Board of Water and Lights, what our position is and how we stand when we read the Board of Water and Light contract with how we contracted them with the easements to put wires, consumer power, the wires underground, and we got an opinion what that easement meant. That would be a formal opinion, or would that be?
That would be a formal opinion in my opinion. But I think there's a conversation about this that we really need to have on this 7.6A, because the exemptions in FOIA that are in section, I think 13, are waivable by the city. And so the question is, does this language constitute a waiver of the attorney-client privilege for formal opinions? And obviously, we need to clarify what the exempt opinions might be relating to litigation, as mentioned, relating to strategy within litigation that we might have, or potential litigation. So when we get an opinion as to, for instance, whether, we have the right to condemn property to extend a bigger sewer line, to take care of that, is that required to be exempt? Or is that something that is currently we're treating as exempt when we should not be? So I think there's a number of questions involving this particular language that we need to resolve here and make suggestions to the community regarding. So I don't know the answer to those questions, but this raises the question in my mind as to whether the charter has waived the section 13 attorney-client privilege exemption.
Can we hear from the city? Sorry.
My only comment, my additional comment is all the things that we're talking about changing. This is going to be the hardest one to get yes on.
Yeah.
Because, no matter what we say, it's like they're giving away the right to see a lot of stuff. So we have got to make sure this is wordsmith and the reasons why. Because ever since this came up, that was been my major concern. I don't know how you ever get this approved. You did a lot of explaining about it.
I wonder if maybe we should get a more formal answer from the attorney as to whether or not this language does indeed waive any attorney-client privilege. I think Mark might be onto something, but I'm also not sure he is.
And neither is he, sure.
Yeah. So
There are places where we talk about the council determining whether or not identifying the document as public record or not.
sure.
And I'd like to see that more be a process of continuous. Every document should be flagged as public or not public. And then if they're public, they just get tossed up into the data repository and we don't worry about it. And then FOIA is the floor. FOIA to me is what we gotta do. It's easier for staff, it's easier for everybody else to say, oh, these are all here. And then that's why I'm saying if we can define formal, we can get a definition of the opinions that would be private. I'd like to manage by exception. And and say, okay, all are public, formal is what's that definition? And yes, those will all be public. And then as they come up, then it's like, oh, let's not make that one formal. This is not formal. That means it's not going public because we're in the negotiation.
I can provide some context. Another municipal client, I rendered an opinion to its council at the request of one of the members of the administration on the interpretation of fair market value under their charter and what it meant. And the long and the short of it is absent, the conclusion was absent an express meaning or definition in the statute. You take the plain literal definition, in the dictionary, and that's what the ultimate opinion was, and there's nothing in that opinion that is protected under attorney-client privilege, and it would be something like that that would meet the definition as stated presently in section 7.6A of what a formal opinion would be, which would be available to the public. In terms of, and again, just a suggestion, to avoid any, and again, Jonathan, to respond to your question, I don't know whether it does, to be honest, but I could suggest that to avoid any question, that consider adding a provision after the word opinions, that's in that, opinion, and then parenthesis, add not otherwise exempt from disclosure under the Michigan Freedom of Information Act as amended.
So I think an issue there is that, to what Jill was saying, is that looks like you're asking for less transparency.
That's what
I can't see that applying, and I'm not sure that's a good thing. We should be asking for it to fly. But when Mark was listing off a list of things, the things that they might get formal opinions on, he was speaking largely of things that it would hurt the city to disclose. And I think that there's also things where it would hurt people, for lack of a better term, to disclose certain opinions. So if you think about the city attorney might be asked to render his opinion on whether a certain employee's conduct violates, is of such a degree that they don't have union protection anymore, that they can be fired with cause. Things like that, where that's not something that I don't think it's worthwhile to. I think it hurts an individual much more than it hurts the city to have that public. And there's a reason why we wouldn't want to, and there's very good reasons to not have something like that public. I think that there's a lot of things to consider here, and it's not just, protection of the city and trying and,
Well, personnel records are generally private.
well, but not if you ask the city attorney to render an opinion under this agreement.
But formal. So I think we've got to use a meaningful terminology. These are formal opinions. These are opinions. And I think of Mark's example as, I want to know if we're battling board water and light, I would like to know what our city of East Lansing attorney's view is on our position in this board water and light relationship. Like that's not an internal issue of the city. That's us, the city, and an external.
Actually, I think the opposite. That to me would be clearly
Attorney-client privilege.
attorney-client privilege.
I said that
Because it may lead to action the city takes against.
Oh, because the action hasn't completed.
Right.
So maybe formal's after. I just think that we really do, because everybody's, this transparency thing just opened a huge can of worms. I would like FOIA. FOIA's our floor. We gotta do FOIA. So what can we do that makes people have, I'm not saying having a feeling, literally, we should publish everything we can possibly publish. So everything that isn't exempted for a reason should be publicly available. So if you could say, yeah, personnel interactions, I mean, you guys go into closed sessions, I'm assuming, for personnel discussions. We always have it in my boards and commissions. And so these things we know, we're in private session, but everything here is public, so.
But the issue, Pam, is that under a certain reading of this provision, anything that the city attorney puts in writing has to be made public.
If that's the definition of formal.
I-
That's what I'm saying. That word, maybe
I
it's a
think-
different word, but if we can say this, we are presenting a formal opinion, and you know that when you say this is a formal opinion, it's a public opinion. It's an opinion that's going to the public. It's going to be publicly available. So
I have a question which might help here. When you ask the city attorney for any of these examples, like the one example about fair market value, makes sense. We should all know what the city's position on what's fair market value. This thing has the opposite of litigation and personnel records. So when city attorney is providing any opinion in writing to the city, we designate that in different ways. Like for the example that you mentioned, would that be designated? Would it not come across as the attorney-client provision? You do something else that comes across on a memo, attorney-client you know, privilege, like this never ending game, but let's say it's trying to get or the thing, right? So
I think it depends based upon the attorney rendering the advice, but I know as a matter of course, if I'm rendering an opinion regarding negotiations on whether to acquire a piece of property or sell, I can't. Whichever one is exempt, okay? I place in the header, this is an attorney-client opinion. It is exempt from disclosure under section blank of the Michigan Freedom of Information Act. That way, and then in the body, I remind members of council that, or the trustees, that if they were to make this available to a third party, the exemption would be lost and it becomes.
Right, and I think that makes sense at so many levels from both administrators just deciding what goes up on the website and council people being reminded what not to share, right? Like,
I think what we need here is, and kind of like the question one here is getting a more formal opinion from the city attorney. Is that, well, but maybe at our next meeting, we can have, you know, some more, now that this issue is flagged for all of us, have a more, you know, a better understanding of whether we think, of whether the city attorney thinks that this provision of the charter waives attorney-client privilege for the city. Because if it doesn't, if it doesn't waive attorney-client privilege, I don't think any changes need to be made. But if it does, I think we need to have a really deep conversation about that.
And if I could just add one thing, I think we're getting into, and I agree about wordsmithing, and I don't have an answer to it, but I think there are various definitions of what constitutes a formal opinion, like there are various definitions of what constitutes a public record. What we think of, what you're talking about as a public record, Pam, maybe is a more common assessment of as what a public record might be to John or Jill Smith.
that's what I'm talking about, yes.
But what constitutes a public record for Jonathan or Jeffrey or myself or Mark sitting here as the attorneys on this committee, it may be an entirely different thing. So I think we've got to figure out a way to navigate that terminology.
Right, I'd like to have wording where we've got all of this generic public, and then we've got the dicey ones where FOIA requests come. Well, I mean, now we use FOIA as a formula, but they're, you know, here's all the ones that become dicey, lawyers get involved, there's fee, that sort of thing.
It seems to me that there's almost like three categories of opinions that we want here. Like the first one would be the confidential or privileged opinions, which don't get published. Then we have the informal opinions, which the attorney would just give at a meeting, like off the top of their head. And then there's the formal opinions, which is like everything else that don't fall into the first two categories that like officially written and then should be made publicly available. But yeah, as it's written, it's kind of like confusing.
Perfect, like that's, yes.
Yeah,
that's- I
ideally
love
there
that.
would be those three categories, like just specified.
And I think people would understand that.
Yes, and support it.
I mean, nobody wants litigation out.
Nobody wants it. And people understand private questions.
Yeah, other than the other side.
Yeah,
Nobody
yeah.
wants litigation.
Right, and that's why when I started looking at the point and even talking, it became a battle, and I'm like, this isn't the fight, this is just a framework. Now you fight your FOIA area, but this stuff shouldn't have to be fought in FOIA.
This would be a language improvement. That's what we'd be looking for, because this has never been interpreted as waiving the attorney-client privilege on a document that is still used. So
It might be helpful to have
it's
a
just-
formal opinion from the
just
city
move
attorney
it.
saying that.
that needs some additional language here to confirm that.
Yeah, if you went to Macon County Circuit Court tomorrow, asking if all the opinions and sit back down and judges would say this is the way. I'm just guessing.
Right.
It's not clear. Well, you would argue, you know, if you went and said, I want to see the private city attorney's opinions, some of the cities would tell you no. And then you have to go to court, try to force it and say, wait, but the city charter says that it should all be public. And the judge would probably say, nice try, but these are exempt under FOIA. Yeah,
Common law takes precedence on privilege. So
I think so.
I'm just trying to take a step back on the city attorney conversation and so the charter seems to contemplate that there will be one city attorney. And I think, I mean, there have been two city attorneys for the past
Yeah.
almost 3 years.
That on my-
You had that on your, okay, I didn't want to jump the gun there, but, okay. And then, okay, that's fine, we can get to it if you.
Well, I don't know exactly where, because we call it a city attorney. I had that on there. What do you do with two of them? Because one is handling one and they're not in the same law firm like they used to be. So Mark, how did you get around that?
Actually, pretty,
Sorry. You know.
That's kind of-
Well, I wasn't on council when they did that. So I'm sure we're going to be taking a look at that because an RFP is going out for city attorney services. And I think the contracts on most of the attorneys expire in February. So we've got to get moving on. And I think there's an RFP that we're going to be taking a look at in a very short period of time. But I don't know what happened to this. Apparently the battery died, so I'll speak up. But I think that city attorney is like it's not singular or plural. It's just an office which is within our ability to fill in whatever way we think is appropriate. And the last council felt that having one person handle the district court work and one person provide specific advice and handle any circuit court, court of appeals, Supreme Court work was the right way to go. And we'll be taking a look at that going forward.
The tribunals, the ones
I
that
think
vote.
we could eliminate that reference to tribunal because I think that's in B actually, and before legally constituted tribunals doesn't really have any meaning if we're already authorizing a city attorney to all cases in all courts. Include that.
Could a tribunal be like arbitration or something like that, though?
well, you have your tax tribunal.
And you don't get specialized attorney?
I thought we used to have that one.
Yeah, we used to hire outside counsel.
When you do what? It depends, like the depth of the firm you have. They have attorneys on staff that could do that because that's their area of expertise.
And the tax tribunal is, why don't you give a definition for everybody? I'm sure.
But you could probably speak to that better than David.
Sure. So the tax tribunal, Michigan tax tribunal, my understanding, it's not a court. No, it's a quasi juris, they call it quasi judicial body. So you might want to keep tribunal for that reason.
And you don't need to be an attorney to represent a party in the tax tribunal. That's exactly right.
Yeah. If that helps.
Put in there. B, that makes sense. Okay, thanks, Dave. How about C? We're doing that, that's pretty standard.
Right.
D.
That's standard.
E. It's our expectation. Okay. F.
Yes.
G.
Yeah.
And H. I think that's true.
Yeah, you get one rate for that home, different rate.
That would be second to a trailing, but so we've got detail to handle district court stuff. We can consider essential legal counsel.
All we did. It's 7.6.
Going. Okay, so now here we're on page 19 of this. So A, the treasurer shall keep in deposit all money We're dealing with 7.7 is the treasurer. That's not going to be the city attorney. That will be fine. You have a deputy clerk for treasurer. You have no duties assigned to that person?
The field of 9 to 7.
What would you say to that, Mr. Bellman?
So the treasurer does all the work. I don't think they have a deputy, they just have other staff under them performing or assisting. And she supervises everybody.
You don't know.
Yeah, yeah.
Okay. We changed names of it.
Yeah, I mean,
So do we keep that person in here? Now, is that person, if we go back to the heading of this, these are the this is the administrative service. Do we keep that position in there with no duties, or do we?
I think, and I don't recall what was in 97, the language, but I'm assuming it's just to allow flexibility.
I wonder if there's duties they're called upon if for some reason the treasurer cannot perform. You know, are there any official state things that need to be signed by the clerk or the treasurer?
So we call them assistant treasurer, not deputy, that's why through. So it's the assistant treasurer.
So we don't have a deputy clerk, so it's an or. So we don't have a
So, I
deputy
mean,
clerk, we have an assistant treasurer.
No, we have a deputy clerk. Because that's Amy Gordon serves in that capacity. But the deputy treasurer.
It looks like they had,
Assistant.
yeah, it looks like what's missing is some duty that they were backing up.
Yeah.
Either or, like one of them had to sign off on the budget and the other.
I think, with regard to deputy clerk or treasurer, purchasing agent, the first nepotism, we can just strike those. The duties of a deputy clerk would be determined by the clerk and by the city manager in terms of their job title. So it doesn't need to be in the charter, any particular duties with regard to them. It's not considered like
Official
a
role.
completely separate office.
Or an official role.
Right.
I just know that disaster response, there's frequently you call out specific titles, so that's what we talked about, like the deputy, a city manager, there may be references to specific positions in other documents that would be vital.
There really isn't anything like that, other than you assign the duties to the deputy or the assistant treasurer, and the clerk assigns duties to the deputy clerk.
Is there, do you think there was a concern that those positions would be eliminated?
No, I think what I need to reflect on is back in 97, they combined or took away all of the financial responsibilities of the clerk, of the treasurer, and assigned it to the chief financial officer. So that's why they took away the verbiage under their titles to allow the flexibility and put it all on the chief financial officer is what the ballot question.
So this remains an administrative service person. Does that have anything to do with that? I don't know the answer to this, though. Does that, are they administration, so they're considered management, so they're not a union position, or is that nothing to do with this?
That doesn't have anything to do with this.
Their own unionized
Right.
administrators.
But I think as has been our conversation in the past, leave these in there, the historical perspective, and show that there used to be duties assigned, but in 97, they redirected it to the chief financial officer. Much like they did under purchasing, they eliminated that responsibility and assigned it to the city manager in 97.
So that's just the title.
So it's just, yes, and then it was repeated. If you look at page 4 in section 3, there's a bunch of them.
Yeah,
It's like just where the,
Yes.
the names are just still there. No.
the titles.
Okay. So even though treasurer 7.7, we have 7.8 deputy clerk or treasurer, that would just refer back to the treasurer, so we wouldn't want to eliminate that.
Okay.
And then city assessor Dave, is right here in the charter. And his duties. And certainly that's just what he does. He prepares that.
That stuff couldn't be more general.
Yeah.
But do you want any more duties? Talk to the legislature.
Okay, so let's go down to nepotism, since we had citizen come to us about nepotism, and the concern was to not have, specifically they asked was not to allow anyone who's on city council not to allow their spouse or partner or family member to be on a board or commission. And I don't know how y'all feel about that.
I would like to talk about that a little bit because, Councilmember Watson did make reference to a circumstance she felt was the use of the relationship in a way that she felt was inappropriate. The circumstances actually didn't unfold that way. So if you recall, it was about a member of one of the council members' family who serves on the police commission, and the cancellation of a specific meeting that she felt had been influenced by the member of the commission who was related to the city council member. The person had volunteered, and frankly, it's been rescheduled, and it's about to be given a Fourth Amendment presentation for members of the community and for the police commission. What happened there was no advertisement of the particular meeting where that was supposed to take place. And the member of the commission who was making the presentation, the Fourth Amendment presentation, asked specifically, should we go ahead with this, given that there's been no public notice with regard to it? And without consultation with that member, the chair of the commission had canceled the commission meeting related to that. Mr. Bellman canceled the actual activity. Not the council member, not the member of the commission. So if we make a change here, let's not do it based on what happened in those circumstances, because that isn't what happened. There was no there was no influence established by the member of the commission or by the council member, probably who never even mentioned it to Mr. Bellman. But as the co-liaison to this commission, I can tell you, it didn't come down the way that it was presented here. It was completely different.
So just a couple other points. So first of all, boards and commissions aren't compensated, so it's volunteer. And this really talks about someone being hired who's related, who will be compensated. And then secondly, they're one of multiple members serving on a board. So it's not just a board of one, but in the case, there's anywhere between 5 and 11 member boards that we have. And so that person serves in one. Of our community is small and it's hard to find volunteers, and I don't know if we want to start restricting more of any relatives who reside in the city from just because they have a relative on the council, serving on a board.
Dale and Joe.
Oh, I was gonna ask if like all these various boards and commissions, do they have like any sort of like their own set of rules that address this at all? Like, does each board have like some sort of code of conduct or something like amongst themselves? Or
They have some have adopted bylaws, yes, but I don't know if they speak to nepotism specifically. I have to look.
Yeah, I'd say that every board and commission, we just had this come up with planning commission last night. Council members sign a document revealing any kind of conflict that they might have. And then if in a particular meeting, a particular issue comes up that the council member feels is a conflict, they raise that issue. And I have done that a number of times over the years because I serve on boards and commissions that might come before the council. And then the council determines whether you're going to be allowed not to vote, basically. I have had one time where the council said, no, we're going to make you vote, so go ahead and vote. But mostly they've said, okay, there'll be no vote by Meadows on this particular thing. We don't require that document to be signed by board and commission members, but they are expected to reveal any kind of conflict and ask to be excused from voting. And I think that's true for every board and commission that we have. That's a different issue than the issue that was raised by the speaker at the podium. So, but that's the system that we've followed for many years here.
Not sure about this whole list of people. I don't think it would be unreasonable to prohibit an appointment to a commission of a spouse or a child of a city council. And that's just my thought on it.
You don't think it would be
Inappropriate.
what if they're already on it and you run for council?
Just like with the nepotism, if you're previous hire, they don't let you go. So
I'm just throwing that out.
No, I know. So that if you're previously on a committee, you wouldn't be kicked off for the employment model. I guess I have kind of strong feelings about this. Totally unrelated to council Watson's concerns. I've been on a lot of committees, even this committee. This is probably the most powerful committee I've been on. We still don't have a budget. We're still just making recommendations. We're still a preliminary path to information going to council. Not even that on the parts. They got the presentation the day before we got it in the meeting. So I'd like to see our commissions empowered more. I'd like to see them getting information first, passing that to council. Council saying, well, the Parks Commission wants this, so we're going to do it. I'd like to see more of that. But as it stands now, we've got just so many great people in this community and we want them to serve and we want to encourage them to serve, even though your wording makes sense. I wouldn't vote for that. That's simple. You can't get it. But we don't, our commissions are not, they're not spending money. They're not doing things. They're just talking. And
I think we're unnecessarily narrowing if we exclude people. It's just, like you said, we've got a lot of talent in this community. We're rare in that circumstance. And I would hate to say, well, if somebody was on council or somebody was on this commission, the spouse couldn't serve on that commission. I think that just is not necessary. I would disagree. My spouse and I used to have very active conversations. Nothing like having two lawyers marry each other. That's a recipe for active conversations at a dinner table. And we often did not agree on things. So by saying that, it's a nepotism kind of things, I think that's a little where we're all volunteers on this committee. I think that's not what's anticipated.
well, and I was accused repeatedly in city council meeting of having a conflict of interest because I spoke up for the parks in a meeting that made no decisions but was reviewing the HUD money. So I'm on the Parks Commission. That's why I was there. Advocating for, or not advocating, just describing it. That isn't a conflict of interest. So the concern of conflict of interest and sharing an opinion, those are not a thing. Like sharing an opinion does not make a conflict of interest.
And I think my thought on, I think that what this vision is very clearly going at is enrichment, someone using their position as a council member to further enrich themselves or their families. because being on council is something very enriching. So,
Or a volunteer position.
right, so I think it's just, I don't know the circumstances of what happened. I don't think that this committee should really care what the circumstances of all that happened were. Because what we need to be here deciding is what's the best policy for the city in this position where there's a policy in the chart. And, my thoughts are, if two people who are married, or if your kid or if your sibling wants to be on a committee, let them be on, like.
Yeah.
Why, I don't understand how that could possibly be a bad thing for, I don't know why we should be narrowing, who's eligible to be serving on committees. Now, if council wants to make a determination that we shouldn't be doing this because there might be a potential conflict, then that's something that a council should, but I don't think that needs to be in a governing document.
Maybe it'd be helpful if we talked a little bit about how people get appointed to the boards and commissions. I mean, everybody here, was interviewed or had an application, that, and recommendations were made with regard to the appointments. We have operating procedures that we've had in place since probably the 70s at least, and have been amended a number of times, but they're specific to how council members operate as liaisons. So the requirement for appointments to boards and commissions. First of all, if on any of the boards and commissions that I'm the liaison to, you have Pam Meadows, who would be better on almost any commission than anybody I've ever contacted, made an application for one of my boards or commissions. I would not entertain that. And I don't think any council member would. We're not going to recommend one of our relatives to serve on a board or commission. It's just not done. But we are required to engage the chair in the interviews that might take place. We make a recommendation to council, but under our operating procedures, the appointment is made by the mayor. So generally speaking, I'd say that in all the time I've been on council, I think I've not had a mayor, reject any, recommendation that I've made, but technically the mayor doesn't have to follow any recommendation of a liaison. So it's not like this person would have been appointed by her husband, who is a liaison to other boards and commissions. This person was appointed after interviews by Councilmember Watson and myself agreeing that this would be a good person on the police commission. And that's the process that we follow with regard to every board or commission. So I'm not so sure that we would ever come in contact with something that would really violate any part of the language of this. You're right. There's really not much enrichment that is possible out there. But again, a liaison is not going to recommend the appointment of any other. And I think in this circumstance, actually, the council member asked to be excused from the vote because their wife was one of the people who was being recommended for appointment.
Ruben, and then Dale.
And I think if we get beyond the appointment process and look at the work that is actually being done, people serving on commissions, as you say, make recommendations to council. And what we have here then is, two people who are related to each other who might be having legal discussions at dinner or not. But the concern here is about undue influence, not about who gets appointed and how you get appointed, but is there any kind of inadvertent collusion or whatever you might want to call it, some kind of undue influence in terms of how the actual person who gets to vote in a decisive way on council, how they're being influenced?
Well, that's a good question because, there's 11 members on on that commission. There's generally 9 to 7 to 9 on every other board or commission. So any recommendation that is made to council is going to come from a majority of the members appointed and serving to one of our boards.
But that doesn't determine how that council member is going to vote.
No, it doesn't, but that's the only thing that's before the council member.
I understand that.
It's what the majority of the board or commission members have recommended.
Right. But we're talking about how that person would vote and how they were influenced in terms of the vote. And whether or not the majority vote prevails, or whether the person that has conflict of interest with a person prevails.
Gail and then Jeff.
So my comment was like on the appointment, process, I was just gonna like put out there, like if there would be any benefit to codifying the fact that like a council member couldn't appoint a family member to a commission, like Mark said, it just isn't done, but I was just gonna say if there would be any benefit at all to codifying that anyway.
Three things. One, I'd be interested what other cities are done. If there's a more some examples of emphasis and policy we look at that might help inform us. Two, I think Joe made a pretty reasonable proposal I would support. If it's spouses, children, I mean, we're talking about 5 or 10 people maybe that are affected. If they're minor children, we may not be that. We're a handful of people that would be temporarily prohibited from serving on a committee. So I don't think that's a real loss in the community. That there could be great people to serve on it, but just, you have an ethics ordinance, point 3, which does require that city officials, employees, and relatives avoid any action which might result in or the appearance of many different things, including giving preferential treatment, even city official economy, impartiality of action things. So whether or not in the real world that's happening, it could happen. The whole point of this is to prevent that from happening. So I wouldn't be opposed to expanding it to some degree. I also know the ethics ordinance has different definition of which family members are prohibited from the chart offense.
I was saying, you don't have partner in here, and that's a key person that should be in this charter.
And just in the athletes, I mean, again, I'm not looking to expand, causing, I mean, I can see if you have 10 brothers, I mean, you might have a brother you hate, but you're like, they could, we're just, in theory, things could be fine, but they could also go wrong. So the point is just to have a process which prevents the problem and maintains public integrity, could strengthen society. And I think the Joe proposed, I would support something like that.
I support Jill's wording, but I question its necessity. And until none of our commissions spend any money, they just make recommendations. So what about people's long-term friends, like me and Brett have been arguing for all these years? He influenced me. I talked to him pretty weekly. Like, when you start, I don't talk to my husband about any stuff. How are you parsing relationships? It just seems like that, what about your employer? What about employers? What about my boss? So I just think
that familial relationship's very strong, and you may influence somebody on a commission to.
Council.
Even if that's nothing to do with money.
But that's why we're all looking at Mark, because council is under ethics pressures. They make decisions, but committee members just show up and I don't know, you know what I mean?
So at minimum, I think we have a definitional conflict with the ordinance. I mean, maybe it's not conflict, but this says ethics, and ethics ordinance different than the term of runners. So yeah, I don't know, maybe that should be that.
So let's
even if we don't expand it to a point.
So, George, let's have Tony come back with the 7.12, where he matches up our ethics ordinance with the terms that are used in this one. So at least and I think we got sent it up. I know we got sent it. Okay. For you. to match up that the language is similar. I just know partner is a really important key one now because you don't want to hire partners. And it's more to the hiring than the commission.
I'm just wondering if wordsmithing on this again, if we're talking about things that are a little different. Reading the language of 7.12 with the understanding that it needs to be tweaked as far as including partner with spouse and stuff. This really speaks to me, the language that's presently in 7.12 really looks at nepotism because it's talking about specifically about shall be hired by the city, shall not affect employment rights, any person hired in violation of the provisions. That all seems to me to be pretty straightforward nepotism. If we're talking about ethical considerations that of the type that Jeffrey wants to track the language of, should we include that as a separate provision within this so that we're parsing what constitutes nepotism and what constitutes ethical considerations?
I think that makes sense.
Well, they have nepotism under 7.11, which this kind of
Oh.
7.12 addresses. And 7.12 ethics standalone, we could put something in there.
Right, maybe we just need to renumber what 7.12 now could become 7.11. And then 7.12 could become the ethics section that would track, we could talk about tracking the language in the ordinance.
Were those combined in 97? Was ethics separate in 97 and that was what was?
That's what I would.
Yeah, it's just there how long.
That was repealed, the other ones in language.
Here's 7. And
Am I wrong?
Well, yeah, I think it's. But this shows that ethics.
so 7.12, they put in there that they should have adopt an ordinance that has ethics. That's what they put in here, so that they amended to add a requirement that the city provide by ordinance ethics. So that's why they added ethics.
Sorry, maybe one other, just because this comes up, maybe this is more for Councilmember Meadows, but, the ethics ordinance doesn't define misconduct in office. And we continue to run this misconduct in office for non-elected officials. What does that mean? Maybe it should be amended, as the ordinance should be amended to that. Otherwise, we just have this provision throughout the charter, which will be created with that for the non-elected official.
Didn't one of the changes to eliminate the misconduct in office, one of the proposed resolutions?
I think we put it on board from previous
Yeah, it's in here several times.
definition.
Do we have a,
Oh, sorry.
You're gonna make the time.
Yeah, I'm not opposed to including the term partner in there. I'm just wondering if there's a formal definition.
on that same, you know, this might be a generational thing. I have friends who refer who refer to their spouse as their partner. I have friends who refer to somebody who's dating for 6 months as their partner. Like it's a very loose term, whereas spouse is not, the rest is not. So I think and before we go and vote in the charter, I think we need to be very clear what it means.
But we do have a definition of domestic, and maybe that's the right way to put it in.
But the idea being that you live together in that circumstance.
We have a specific ordinance definition of, within the zoning code of a domestic partner, and that would be a non-traditional, marriage, basically.
That works.
And maybe for next meeting, if we get just a copy of the zoning provision on definition of family, which has the domestic partners, that would be helpful for people to look at it.
All right, well, I think then, we have a few more in 7.
Hey, I want to just add one more thing to that discussion, because I see sort of a split of opinion, around the table, but, we are the third most educated community in the country. And so there are a lot of spouses out there who can make positive contributions to this community aside from their spouse. And that includes council members. And so the whole idea of sort of cutting the opportunity to utilize that expertise is something that I think really needs to be thought about when we're making a decision.
7.13, restrictions concerning other offices. No city employee or administrator can seek an elective office of the city of East Lansing unless he or she resigns from their position from the city. Having the city manager, that the city manager, it's a 2-year thing, can't run the council. There's something, have something, or do I have that backwards?
Yeah, that council can't be employed.
Yes, a council member can't become the city manager for 2 years. Do we have any concerns with this? Because that's the only place that I saw that there was another place where we referred to this. And when you say, when you read this as seek any elective office, if they put their name,
Thank you.
you put your name forward to run, you have to resign before you do that. Is that how you read that? For seeking?
I mean, there's a formal process. I mean, there's a formal process for declaring your candidacy for an office, I would imagine. Can't be employed by the city and just file that paperwork.
I think there's only two things. Can't run for city council without resigning. You can't run for district judge without resigning. So, I mean, I can't think of any other
Is that,
elective offices of the city of East
I think
Lansing.
the elected officers are just council under the definition.
yeah, I agree.
So it's not even just.
District judge doesn't fall under the office. Is there by the state and not under the city?
So elective, you read elective office of the city of East Lansing is only involving council.
Right. It says city.
Yeah, 3.1 says the elective officers of the city shall be 5 city council members. So that's where I was getting it from.
And that's it. There's only one office that would.
So, you don't see anything with 7.14. And, 1.5 is pension and the benefits plan, those two things. So we'll come back to 7.17.12, with the, when we deal with the nepotism ethics and possibly relabeling them and getting new language or starts with different language to match.
Is there an ethics ordinance? Is that what we?
There, that was emailed out.
Oh, we got that.
And would it be appropriate to maybe take a straw poll conversation we were having, just to kind of see where things are right now? It seemed like things were a little divided. I don't think that we really know where we're at in terms of.
Sure. Who would like to limit the relatives that can be on boards and commissions if their spouses or domestic partners on council? Would like to limit that? Raise your hand. Where I sleep one. And our two others, do you want to put your input in? Because we value you being here. It's not formal approval or anything.
Yes, I was for not restricted.
And not restricted.
Where we're at.
52%. Well, I'm not a 95.
And I liked your wording. Your wording sounded reasonable and
But I can't. But
Here, yeah,
that is on fire.
um, okay, so, let's go on now. So we've done that 4.3. Now we're getting to our, possible approval of some charter changes. So we're gonna go 7.2. This was, changes to the city manager, designating a department head, and we talked about whether it was the resident city. Did you get more information on that from Tony?
Oh, yeah.
Or within the distance with the stuff that you sent with him?
Yeah, we actually talked about it yesterday, and the requirement is if you want to put it to. You have to find the correct file. The only comment is the specified distance of greater, it doesn't prohibit you from doing as long as it's 20 miles. If you wanted to do it.
I think
No, not less,
Not less than,
not less.
a person reside within a specified distance from the nearest boundary
15
of the public employer.
He doesn't have.
However, the specified distance shall be 20 miles or another specified distance greater than 20. Gotta be. Which doesn't make sense, but that's what the statute says. I mean, believe it or not,
it's like both sides of the issue.
So it can be 20 miles or more.
Right.
As a non-participating member of the committee, I still think that it would be advisable for us to include a geographical designation that it be within 25 miles of the city limits in accordance with 15, in accordance with state law.
I tend to agree with that. We talked at the last meeting about the city manager has a lot of authority and a lot of job requirements that require them to be available on short notice. So I think it makes sense to, chaos is breaking out at midnight for them to be able to get here within a half hour. Makes sense to me.
And that's in the disaster, that's on the negative side. On the positive side, I'd like to see a city manager who's here often and can participate in the activities of the city, who knows everything that's going on in this limits. So, and so that they can respond if things go south.
Yep.
But somebody who knows the community inside and out.
Yeah, and I definitely support too, from a disaster recovery point of view, it's gonna be the city manager that has to declare an event response. And so the geographic, think about these horrible things, but anyway, but also.
So if I may, clarity, that's not the case under state laws.
No.
That declares.
It's the difference, but we'll talk in the future about the city's disaster recovery response plans, but, they declare federal action or anyway.
Call it the National Guard.
Yeah, yes, but also there is a huge problem with people staying in critical roles like this for 2 or 3 years. I'm thinking of school superintendents. And if a residential requirement tends to make people keep job, you know what I mean? Like I want an environment where we're hiring someone who we expect to stay for a while, not to, I know a lot of people that they just keep their house and change these jobs, and they're critical leaders, and they're gone in 2.5 years before the program they initiated is even up and running. So to me, it might also Love you, Robert, I would just, but you know, like it's a way to, it may be a way to hold, people are making a decision, I gotta take this job, it's gonna be for real, I'm gonna have to move. You know, it's a commitment
Right,
kind of
it's a
situation.
commitment situation. The other thing is that I know that we're dealing with the realities of remote work. And having, you know, there's nothing that would preclude if we pull a geographical requirement out from having a city manager who lives in Marquette and is managing the city of East Lansing. And I just think that that's untenable.
How likely is that?
Could, I,
Do you think, I mean, I'd like to hear from Councilman Meadows, would you guys?
I would say it's very unlikely, but I would have to ask George. Notwithstanding state law, can we contract with a city manager to require them to move into the city within a certain period?
yes,
Within
I
20
mean,
miles.
presumably,
he can do it.
we're saying, if you want to work here, you're gonna have to work, you're gonna have to move into the city, and we're gonna put that in your contract. So does a contract trump
No,
state law?
the state law would supersede in that,
But 15602 says it can be provided by contract, if I'm remembering the statute
The 20,
provision correctly.
under 20.
It does, it
A
says,
public employer shall not require by collective bargaining agreement or otherwise. So it doesn't have to, it could be a CBA or it
is
could
that
be a member.
601 or is that 602?
That's, I'm looking at 602.
Okay,
That a person reside within a specified geographical area or within a specified distance or travel time from his or her place of employment as a condition of employment or promotion by the public employer. And then subsection 2 says, subsection 1 does not prohibit a public employer from requiring by collective bargaining agreement or otherwise that a person reside within a specified distance from the nearest boundary of the public employer. However, the specified distance shall be 20 miles or another specified distance greater than 20 miles.
Now, this is not Michigan, but any number of states have an exception for a residency requirement for a city manager. By title.
So just to be clear, we can require that the city manager live within 20 miles of the borders of the city of East Lansing.
Yes.
Okay, and it has to be the borders of the city of East Lansing, not the city hall,
Right.
the city of
no,
East
it's
Lansing.
borders.
Right.
Okay,
And we could require them to live, like, let's say that currently the person that was the best candidate that we're looking at lived within 25 miles. That allows us to extend it to 25 miles, but we can't do it less than 20.
then are you suggesting that the language reflect that?
I'm hearing 2.
Yeah.
Before. I'm there, Ruben's there.
I'm an A.
I do feel that the council needs flexibility so that it isn't for instance, this typically says any contract you sign with somebody, within 90 days, they've got to live in the city of East Lansing. That's what your contract has to require. But we do need some flexibility. You know, we have a circumstance here that we've dealt with. Robert lives in the Saginaw area. His family, his kids are still in school there, things like that. We should be able to massage this a little bit, so that this is not a requirement that they live within 20 miles, but that we can require that in a contract or not require.
And I have one point for you, Calvin. I agree with what Mark said. That's what my concern was, flexibility. If you need to change city managers, it's not easy to find qualified city managers. They need to go outside of 20-mile boundary. They have someone like this gentleman, time practically removed, he's doing a job. I think the city should have that flexibility. That's why I agree with the point of it would be great to have a city manager like fully vested living within the city, but not already allowed to require that. So I don't see have it on there for a couple of reasons.
I guess I have 2 suggestions in response to that. One is we could grandfather in any current employee, which I think might be a good idea for that kind of for anyone. Two is, the language could say, that the person must, that council must contract a person live within 25 miles of the city in a period not to exceed 1 year. So it could be a contract thing where, the city, if council wants to stay 90 days, it's 90 days. If they want to stay 180, it's 180. If they want to stay a full year, it's a full year. I think that gives flexibility that Mark is saying is required here.
Joe, what about they have to live within 20 miles unless waived by the city council?
Well, that works.
Yeah, that would be a choice.
I wouldn't say, I would probably phrase that, that the council may require any city manager contract to provide that the person live within 20 miles and set an appropriate time period for that to occur, something like that.
I get that, but also part of me thinks that this is a good idea. This is a good idea. And if it's not a good idea, then we shouldn't do it. And if it's a good idea, it should apply in all circumstances.
But what I hear Jill saying with her wording is, if it's the conscientious, you will have to say why we chose this candidate that lives outside the city. Like, it won't just, it'll be like, why are you waiving this? Well, we're waiving this for these reasons. So it'll be a public discussion about the waiving of something that we all think is a good idea.
Yeah, I like the idea of having it be the requirement unless the council goes through the explanation and you have the public documentation and discussions and things on record to explain why it's not being that way.
Yeah.
Yeah, I'll just note that, in terms of city attorney performance, the distance can become irrelevant in terms of the detail of the contract, which could require that the city manager be available beginning at 8 a.m. on any workday, be available in case there is any trouble in the city. We can add language that puts a real restriction on how the city manager must be available, which is the key element here anyway. So I think your suggestion is a good one, as long as there's some flexibility for council as to how that's going to be implemented.
It also doesn't address Lynn's, which the availability is one side of it. The other side of it is you want that person as part of the community, and you're allowing that person. And we're talking about person, we're not talking about you. Okay, so I'm just, this is going through our.
Yeah, come out right now, just a black shape.
Because going for, again, I think of what Jill pointed out before when we talked about the city attorney. I think this is really hard to pass, or this is going to be hard to explain to the public. So you take this and you say, oh, city manager doesn't have to live here in the community. Oh, and someone would say, oh, that's the new law. But we're explaining that we want them within a certain distance, but then we turn around and say, but you can waive it. And you're thinking, it's like you're sending a double message to the person. I think that it's better to say there's within a certain amount and you give them time. I don't think if Robert knew that that was in the charter, and if we had a consultant that was out there searching for city managers, that would be in the requirement, that would be stated in the thing.
Right.
You would not have applied to that, if you didn't want to take the chance to move, or you thought that's a no. A non-starter for me. So I think it's better to put something forward. And I know in contracts that we've had with different city employees, that we've contracted with, like the library and also the city manager, moving expenses are covered if you got extra bonuses if you moved into the city limits. This isn't even in the city limits, but if you moved into the city of East Lansing, got a bonus because we want you to be a taxpayer resident versus living in Meridian Township. There's a benefit for us for that. So there is ways to put it in the contract to give flexibility and incentives. But I think by having something pretty structured in there, in the charter, I think also it's like we're waiving and saying it's okay, we can have everyone. And I'll go right to that everything's remote now. We're trying to preserve that we want our community to be led by a city manager that's going to be here.
I couldn't agree more. So, I think that there's some flexibility built into it. It looks like we have to work on this language anyway. So I think,
I would say
taking
within a
everybody's
year, once you
comments
got would you say within a year? Because 6 months is hard to pick up a family and you haven't tried, to be a city manager here and it might not work and you have a year to make that decision before you uproot a family. And I think that that's a much better, and if you do within that year, then that might be in a contract, some incentives. But I like the idea that, can we use that language that's in there? And, because and put that right into that paragraph.
Sure, you could.
So I'm just gonna toss out, so I will say, in the 32 years I've worked in management, I've always lived in that I've been employed. But that is no longer the practice among my peers. And so, yes, you could write this in, requiring it, so that I come and get an apartment, but I'm not relocating my family. Does that automatically get what you're trying to achieve? That commitment and that participation in the community. It's truly gonna be the individual that drives that. Just because I live here doesn't mean I automatically will get involved or be part of the community.
Well-
Yes, I'll be accessible for
And that is-
emergencies.
Totally what's happened on campus. So at one point in the last 4 years, I've had 2 IT directors that different moved, like the Massachusetts and yeah, so.
I got
And
you.
and the apartments, the 55 and over apartments, there are 3 or 4, maybe 5 now, high-ranking university administrators that have apartments over there, and their family, they didn't move, that's their apartment, yeah.
Apartments.
I think you just made a great point. This is what I had in mind, is you could be living here, for lack of a better term, every single day right now in the apartment city, but you want to keep your residency in Saginaw. Use example,
Right.
whatever reason, tax reason, family, whatever, so. I view it as an unnecessary burden on the city's ability to attract talent that could be gotten around many different ways by providing housing, by requiring you a contract. The law already requires you to be able to, or allows you to be able to do all the stuff in contracts, so that should not be put in the charter as a restriction. And I like the idea suggested in a way that also the point of that's, it's a little dicey selling out to the public thing.
Yeah, I don't know why we have to sell that.
So, well, all that is, don't put it in there at all.
Well, I think it's jumping on a big. I hear your argument, I hear definitely the argument, I definitely watched it, but I would love to see us try to not get on that bandwagon. Like, I would not want, hiring these people that are only gonna be 2 or 3 years, get an initiative going and then move on. Maybe that's not the pool of candidates we need to be looking at. I mean, we need to be looking at it.
Maybe.
I don't
the
see
city-
much sign of them doing quality work.
Well, maybe the city temporarily needs to bring someone in from outside, because they're gonna switch to residency, and the whole point of the rules. Temporary.
Okay, but, even under the language that is currently in here, somebody could have bought, one of the condos that's right on Saginaw, become a resident, registered to vote in the city of East Lansing, and spend all their time at a house in some other location. So I still think that, having some limitation here and requirement for residency works and is a valuable thing for us.
And I hear Jeff's concern. Maybe we're getting a different pool of candidates. I think people really have to look at that. So maybe we're not looking for 6 previous city manager roles. Maybe you had a different management role. Maybe, if we can't get anybody, that's what schools, I really want schools start looking at that for superintendents. When people start looking at, maybe this career-minded person isn't the right candidate for this role.
I mean, I think we're kind of getting lost in the weeds here.
That's where I was.
This is ideally a person we're hiring once every 10 plus years. I mean, the prior city manager was here for 11 years, if I'm right. Robert, we hope you're not going anywhere. Like, so, I mean, I think, with the getting in, and I think that having, as Pam is saying, having a residency requirement encourages stability. Because it just does. My when I bought my house here, my boss told me that was a very happy day. So like, it's similar in terms of what we're talking about is what we want as a city manager. I do think we should have a grandfather clause. I just want to throw that out there. I'm not hearing any disagreements from anyone here. But I do think, moving forward, it's a good policy that the person should be in.
Whether it's on, on Saginaw Street, a small condo, or 20 miles away, it does provide an opportunity. We usually can, there is some predictability anyway of major circumstances that cause a disruption in this city. Like after every Final Four basketball game.
Not never.
And then in those circumstances, the city manager is probably going to stay down here because he knows that he may be needed that night. And so I think that what you're suggesting is pretty much the right way for us to go. So that also has a time frame in which this must take place, but it encourages stability within the community. I think we can accomplish that even without this requirement that they actually, buy a house in the city of East Lansing.
Yeah, and if we use the language that's in the Michigan code in our ballot proposal, we can explain allowed under Michigan code. We're taking out the old language that isn't allowed and we're replacing it with something that is. That also will be a message to the community too, that there's something in there that's current and is allowable and sends the same message. There's some flexibility.
Diane, when we use that language from the code, if we could tweak it, because it just says it has to be greater than 20 miles. I'd like to have us, put an outside limit on that to be greater than 20 miles, but no less than 25 miles or whatever. But I'm just
We can say
so bitter.
within 25 miles.
Within 20 miles, within 25 miles. Track the language in the statute, but puts it within 25 miles, then or within the statutory provision. But because there's no outer limit on that, the statute, I think my goal, at least in proposing this, was to at least say circumscribe that
So we'll be within 25 miles of the closest city border.
of the closest to the
City
borders.
So
Yes.
if we could say, replacing the language that's currently struck out in the current resolution, say, and need not be a resident of the city at the time of appointment, but shall reside within 25 miles of the city within 1 year after his or her appointment.
Sure.
And I think
Everybody okay?
under state law, if anyone's interpreting what within 25 miles means, it's very clear. I don't think we need to get
Right.
nitty gritty.
Right. Under flesh.
We have for future hires.
Well, yeah, I would also suggest, and Tony and I talked about this yesterday, I apologize. That it would say for any newly hired city or any city manager hired after the date that this amendment becomes effective, or words to that effect.
I think we might need to massage that, because it's my understanding, Robert, you're under contract, right? So when your contract expires, are you hired if your contract, if you renegotiate?
Any new city manager.
I think it's just easier to say this provision shall not apply to anyone currently working. in the
Okay,
city
that's fine too.
At the time of the
At the time of the adoption of the amendment.
Well, I just wanted to add, I'm in agreement with all of you, however we wordsmith it. I think that also having that in the charter, specifically as we're going to get it eventually, would be a good underscore for way in the future, when we do put out a post to hire a city manager, that language, that posting is going to speak to, the vibrant community of East Lansing, Michigan, be wanting them to come and be a part of this community, and then we have that underscoring it in our charter.
Greater Lansing area.
Greater Lansing area.
So we'll see this one back on 7.2. Okay, going on to 10.2. This one is what we got from the finance department. They put in the budget calendar at least 6 months prior to the next fiscal year. and no later than April 15th. I think that's what we all agreed to last time.
Russ wasn't here last time. I just want to get his thoughts, make sure that this is consistent with how he would want to run things.
But I had talked to Owen Valley before he came, and I liked a lot of his suggestions. I think staff is just asking for that flexibility in April because we ran amok a little bit this past April where we had to ask council to cancel their first meeting and move it to later in April because it was April 2nd. And we couldn't get a finalized budget by then. I just wanted to make sure that no later than April 15th was clear that it meant submittal of the budget and not the budget calendar.
I think that's how we understood it, right? Okay, so if everyone's comfortable with this, need a motion? Sorry, it's been moved by Martinez and seconded by Wilkerson Johnson. Any discussion on this? All in favor, say aye.
Aye.
Opposed, same sign. All right. 10.2 is approved. Okay, next going to 10.4. This is where we just, after much discussion, we decided that the proposed budget should be on file and we enumerated where it would be. It's for people. Don't have any concerns about that. Not.
Just reflects reality. That's what we're doing.
Yeah.
Yeah.
Need a motion.
So,
Okay, it's been moved by Foreman, supported by Sport. While, for discussion on this. All those in favor, aye. Aye. All those opposed, same sign. And it's approved. 10.4. Now 10.5. We were supposed to, one of the things in our minutes said that we were going to see how the changes affected by the city assessor to make sure that this change didn't cause any problems in this. Because we changed it, the last regular meeting of city council in May, we just put it May 31st, the last day in May.
And there's no impact to the city assessor. So the city assessor role in the budget process, other than preparing his own departmental budget, is to project the tax revenue to be generated, collected through that.
And their recommendation was that it be June 15th. And I said, there's no way to do
No, I don't want to go later than May. I like
That's why we
also adopting it in May, because then you can relax in June before it takes effect and kind of get everything ready. So I like the way it is where it's in May.
Okay, so we took their recommendation and just, instead of the last meeting, made it at the end.
Okay, motion to approve 10.5.
just let me say one thing, generally speaking, it's going to be adopted in their last meeting that we have scheduled in May. But this language, if there is some kind of screw up that takes place at that meeting, this allows us to have a special meeting so that we can get this done by the end. And so I think this is really good. Language.
Okay. Motion for 10.5. One else speak at once. Okay, moved by Foreman. Supported by Martinez. Any more discussion on this? Okay, all those in favor say aye. Aye. All those opposed, same sign. 10.5. Charter. Amendment is approved. Now we're on 10.9. 4.7 in our agenda. This is to change within 90 days of the close an annual report of the city business. So we did talk about this last time and felt that this met both what his concerns were. Did you have any concerns about this?
I'm not sure what this annual report is. Everybody I've talked to has a different opinion. So, the city under law has to put out its annual comprehensive financial report, which is due within 180 days for close of fiscal year, you know, this 90-day annual report, you know, where I'm still trying to figure out what that is.
Is it pre-audit and post-audit?
It's the calendar.
So the calendar's not issued until January, which is 6 months after the fiscal year.
So,
No, December is 2022. So that's why,
That wasn't how it used to
Yeah.
be.
well, that's where it's been, but when you even look at the calendar though, it's calls itself an annual report, but it has no financial information.
Right, that's what you talked about, that it's
And it
generally
really doesn't,
heads up.
it's not comprehensive. It picks up highlights because of the space limitation.
But as we talked about it, it was, if there was a large deficit or some heads up, that would be in that report. That was the discussion we had.
If there was what, I'm sorry,
If there was some like big deficit or some big issue,
right?
that would come up in there and we wouldn't have to wait until the audited final report to get a heads up on it. So
Understand.
that's why it was determined that it wouldn't be too hard to do because it didn't have all the numbers in it. It just had the general overview of the city looking good, or we still have a liability.
Language is been in there, but I still try to figure out as I'm learning the organization, what is this annual report that's due in 90 days?
I'll just say, council has been saying, you know, in our own conversation, say, where's Robert's report? We never got one. Well, this is the existing language, and all you're doing is moving the
Yeah,
language from the bottom to the top.
I mean.
But I don't think there's any format that is actually defined in here. So I'm trying to remember whether Ted or George ever provided us a report consistent with this within 90 days of the close, which would be July, August, you know, October 1st, basically. And we have got, you know, I mean, it really only requires you to make a presentation, I would say, about the close of business of the last year. And it was just pointed out to me that on our calendar that we passed out, we have provisions that say taxable value of home, blank, tax village, blank, total taxes, blank, taxes kept by the city, blank. So that's the kind of report I think we're actually looking for. But does this need more explanation? I guess is the question.
That's very tough.
But as I read this, it's the activities and finances of the city government is what makes up this annual report. The calendar doesn't achieve that. It does highlight city activities.
Yeah, the discussion was, it would just be.
Facts and finances concerning, so it's pertinent. It's very general.
Yeah.
To get.
Yeah, it's like, you know, you can.
But I think of this was printed sooner, but this doesn't get printed until December, which is still 6 months after the end of our fiscal years.
No, but you could. It doesn't say it has to be written. It's a presentation to council. You know, here's what, you know, here's how we ended the fiscal year. These are the activities that we were financing. Here's where we are. And, you know, I do think that in some sense, we have gotten that information. I don't know if it was within 90 days. But
I know I don't have a problem with the requirement, I was just trying to understand what is it? It's been in the charter since 97.
Well, my understanding, we talked with the accountant that was here for the city. Anyway, was talking about the idea that it would be a heads up if there were trouble. So
I'll tell you that'll come sooner than.
well, I'm just saying, like, it was as we reconcile the budget, we're getting less tax revenue, we're not paying off the liability as quickly as we'd hope, you know, there's, you know, just a high level executive summary of the city's previous year.
The only, I know you just basically moved it from the end of the paragraph to the beginning of the paragraph, but
You understand why we did that? Because that came first and then the audit came second.
which is fine, but I'm more concerned about the word published. Now, if published is the act of Robert making a report to council, oral or written, and that in turn is published by virtue of the minutes of the meeting, I think that meets the definition of published.
I'm with you.
That's my only concern in terms of what constitutes it being published.
Sure.
But if we're changing the language anyway, shouldn't we just make that clear and say presented, instead of published, so there's no confusion?
There you go.
Presenting city council, but could we, it's also, to my way of thinking, I understand what Robert's saying about, well, what city business is supposed to be included in this report? What is the responsibility on the city manager? What kind of report is he to be making? Is it supposed to be what's in the budget, and did we exceed the budget? Is this where our revenues that were collected were detailed? Is it all of that? Is it part of that? I don't know, and I suspect I'd be in the same, that's the same question.
We did discuss it though, I thought.
I think it's pretty like what's the up to the discussion, like whatever he wants to put in there.
And that is kind of what we decided. It's a state of the city report from a city manager.
I would say that this is intentionally vague. So that, nobody's going to sue us over the failure of the city manager to list every pertinent fact. It just says pertinent facts concerning the activities and finances of city government. So what's pertinent to me might be different than what's pertinent to you, but
But unlike as a citizen, I'm not really interested in reading the audited budget and every line of the budget. Yeah, lovely. I want an executive summary, and I also want a heads up. So it's suddenly we've got this huge problem. Well, what? Like, I want like a heads up of, like what would you just say that you've got all the debits and credits in? How are things looking? Just that high level.
It seems to happen, the last meeting we have in June, do all the budget switcheroos to make sure everything is balanced. You shift money around to make the balance. And so then they're giving you 90 days to come back and present something. So whether it's published or not, if we want to change it, it's presented. Are we okay with that? Or are we going to say publish, or are we going to present? And is that, and then we go on to later, it's the 150 days, which is.
That's a presentation to the council. And those are printed minutes, right?
So do you present it to the council?
No, I'm just saying that the minutes themselves can constitute publication.
Right.
That's what we're gonna get a word for presentation in minutes. Right, so I mean, I think, when we're looking at what this means, we all understand what the language means by published, but hope we all understand it doesn't matter what matters, what the word actually says.
Well, if we want citizens to be able to view it, I think it makes sense to have a document that you can go look at. Here's a
But
handout.
right now, we don't have that, right?
Right, but poor Robert's trying to figure out what his should look like.
I'm kicking back to the previous discussion. I think Diane was saying that as I talked about I think I'm putting it out with the winter tax bill or something.
That's right, yeah. That
But
was,
Diane pointed out that on our calendars, we usually get a pie chart as to where their revenues were going and stuff. And I picked up the calendar the last couple of weeks just precisely to find that out. And it is there. So if this is the annual report, that's helpful. What wasn't helpful is what do property taxes pay for? And this was the sort of, taking a SEV of 100,000 that nothing's in there. So we can't see where things are dispersed. And that's a noticeable oversight.
and I think that point is well made too, because this is a chance for the city manager to go, oh, FYI, your taxes are well spent, or here's the legitimate uses we've made, or,
So
it's a PR for the.
I was going to say also, if it takes the form of a presentation, like the council meetings are typically recorded too. So citizens can review the video, and then there's also, I believe, on the city website, like a place where they put like their budget and all that information, they could probably have like that presentation done there as well if they wanted to.
I'm assuming that the presentation would not be without documentation. Unless.
Oh, no, I agree, yeah, yeah. They won't let it go by without documentation. Where do you come up with that? I just wanted to have a better understanding because everybody I've talked to so far is expecting a separate document.
No, it was never separate. It was always the calendar and they put it out before the end of the year because they were picking it up so you had it in January to start using rather than putting it out in January.
And that's good to know.
But, how do you want to change this? Does anyone want any wording change to this?
You know, I personally don't think we need a wording change here. We just need, although I like the idea of presentation rather than publication, just so there's no confusion. And but I think all this requires, and maybe going forward, this is like an easy fix, which is within 90 days of the close of the fiscal year, you're going to have on one of the agendas a presentation on sort of the basics of what happened the year before. And you'll have a memo that is, attached to that. And that's it. That's all you need to do. This doesn't have like giant, detail as to what it is. So it's going to be pertinent facts, which are we going into bankruptcy? And you're going to say, no, and then we're done. So.
And you weren't here last time, but the finance department was really worried that if after the audit, they had to change some numbers, that they would put something out before, and that wasn't the intent at all. It was a very broad thing, and that's how they got it.
Do we really want to put on the ballot to move this paragraph up? That's our only change.
Well, that's a good point because this,
Do we want to change published to presented?
Well,
Or you're going to have to indicate the nature of how it's delivered, just we eliminate shall be published. And to say that the city council, that an annual report will be,
Shall be presented, say shall be published.
shall be made. A good point, Jill. It's the way my language being not necessary.
what?
Yeah.
If it's shall be made is even better than shall be presented. One of
Yeah, maybe just.
but also bring your half the voice in there. That makes being a stickler.
English teacher.
Yes. I shall be made.
Do you want to say?
That just say the city manager shall make an annual report of the city business and such.
As Jill's pointing out, are we really making a substantive change enough now that Robert's clear? I mean, is that?
I think we actually are by changing it from published to another, to make it,
But
that's not anything to be expected.
But everybody agreed what Mark said memo, I'm like, that counts. But I do think we want or the calendar, we do want some sort of document that citizens can have in their hands.
I think that's two different things to talk about, right? Where the 90 days and 180 day.
The 180 days, the full audited budget with everything in it. The 91 is just an overview, a graphics and smiley faces.
And I think that I don't want us to not allow something like this to get to the citizens, because I have heard, and I've been one who says, look at every time the tax bill comes in, is holy cow, what am I paying for? And this is a pie chart important. And this is a nice answer. And I think that this is useful to everybody. So I don't want to do anything here that would
Change that.
suggest that we shouldn't be doing this.
And well, let me ask this question. What's the magic of 90 days? So why not make it 180 days so that it's by the end of the year, by the December 31st? We always publish this calendar towards the end of the year. The calendar can provide this information. It's in a form that everybody can take home and keep for the rest of the year and look back on it. It makes it a lot easier. I don't know why the 90 days was chosen to begin with, but if we're doing this in this way, which can be understandable by everybody, and
Well, the other thing is it does tell you with each month what each department has been doing
Right.
over the previous fiscal
Yeah, I could see
year.
that beats the.
And we did treat this as a report when we started. Originally, we were mailing it to every address. And maybe we need to start doing that.
I do that.
I would do
And
that.
and even though there's a cost involved in that, you know, I can tell you that my wife asked me last week, she says, where's the city calendar? You know, I would keep all my notes on there, you know, and I didn't have that yet.
So I think my confusion is coming in is, I don't think the calendar, I mean, it's not out September 3rd, so I don't think the calendar is the publishing that we're talking about here.
You're right.
It could be,
But it could be,
change the date. So-
yes.
Right.
And so and if we made it more clear that we actually, when we say published, we actually mean published. We need something in writing that's presentable to the public. But I appreciate what Lynn is saying, because I think that might be the right move here. It's just I don't think that the calendar is coming from currently. Charter.
So what did you suggest so that we have the red moved up there like we did, just because that comes, that's different than the audit? Would you say 180 days after this shall be, just leave everything there, shall be published? Because within 6 months, it will be published after the close of the year, and it leaves it very generic, and it's just, we're giving more time, and in our ballot language, we can say, this allows more time for the finances to be finalized and the city council members to be on there. I mean, that, the new city council members.
But the real final is after the audit. So we've got this, and then we've got the audited full budget document that's also public.
I think what I would change is I would say that the city shall publish an annual report of city business. So take it away from the city manager, which makes it seem like it's something that he's presenting, that it's just that the city manager has some discretion in the form of the publishing, and just say that it's the city shall do it.
Just strike manager.
Yes.
The city in such form.
That's still means you're right.
But when you say published by the city manager, so like, okay, the city manager gets to choose how.
No, it's
just,
So I think we're talking about a lot of different things now, so we need to kind of.
I've got 180.
so if you say within 180 days after the close of the fiscal year, an annual report of the city business shall be published by the city in such a form as which will close.
that was all legal. He told us that they had to do that, the audited. But full budget, that's what was permanent.
Okay.
What do you know, but we're gonna change. We're not touching.
Right, so now we're gonna have another 180.
Yeah. And then there's an independent audit, you know, because
If you want to get really specific, we can say it has to be done by the county. I don't know if you want to get that specific. But that seems like a lot, but.
And we gotta get that calendar out before.
That's what I was just gonna say, so that's,
It always is.
July.
Within somebody's available,
Yeah, so that's.
if you want to get the city council, who's your city council people for the next year, you want it after November, so you might as well just make it after that. All right, that one has to come back to us. All right, that was 10.9. Now we're on to our favorite, chapter 8. So you just talked about wanting to have some more information for chapter 8 for next time.
Yeah,
After Mark, with Mark chapter.
yeah, I have some notes on what he suggested, those briefly. So really, stepping away from last meeting, I just reread this, and we're not actually increasing transparency at all, except for the website. It's really just a reiteration that the city's subject to state law, OMA, and FOIA already. So there's no real change in transparency. So if we're going to present this as what proving transparency, it's sort of just not really. So, and I listened to Dr. Ruber sometimes. He said here, what's the problem we're trying to address? It's change. Problems with One, it's just there's a lack of transparency. Those one problem we try to address by improvements. Two, with FOIA, one of the problems you see is delay in processing FOIA. There's an initial time period. There can be more time requested by the city to send in. Third potential problem is that there's a lot of money charged. So, Pam's brought up FOIA is the floor. So we already have an in-city ordinance in the charter circumstances where the city provides documents faster than what FOIA required. There's multiple systems that we start at. So some of the ideas that Mark had was that and we use the term public records and documents. I mean, I think we all sort of think we know what a document is, but the document's not defined anywhere in law. FOIA uses the term writing. Writing is very broad. And then it uses the term public record, which contains writings unless they're otherwise exempt. So we should probably change documents, the word document. But generally, what we do is try to work with Mark this language on this. I'm sure Pam's going to have some comment too. Something along the lines of writings available on the FOIA that are that departments have a plan to produce for inspection or on the website writings that are repeatedly requested. So if there's documents we know that are repeatedly requested by people, make them available or have a plan in the department to identify in advance those documents that can be made available to the public at City Hall or on the website. Respond as immediately or quickly as feasible. If for some reason you cannot do that, to provide a specific reason for that non-production that is required to be made. It suggests that residents and taxpayers have immediate access to the documents or some examples that are ready in the city charter, city code. Like, for example, you can go and look at rental housing records by showing up. Some common documents that you could already access. A proposal that, because FOIA allows for certain charges and costs, that you only bill a percentage of those costs, for example, particularly, or we have a policy that commonly identified documents, there's no charge for members to get those. And that, sort of document, a policy with the city generally that is willing and freely provided under FOIA to carry out not only obligations, but the spirit of the law, and that's to properly disclose without charging necessarily or without unnecessary redactions. And I think I sort of already said this, but that each department would be directed to design a system to reduce burdens of storing the information to make it efficient to produce such information for these documents that we either identify or that are repeatedly requested. And I know that's sort of probably confused the way I just explained that, but I think we put this in 3 or 4 sentences, which would solve all the problems. Increased transparency generally, but also solve the 2 or 3 problems that we have.
I just wanted to say, because Jeff was saying, great, keep in mind, should this be where you're saying no charge? Should it be, you say to the public, should it be to our residents? Because you have a lot of third parties out there.
Yes.
Getting information, selling it, making profit off of
In
it.
the notes, I have residents and taxpayers being free of charge. I question Governor, well, can you do that? Make a distinction between residents and taxpayers. Again, this is just his opinion, but this is some of his Albert's attorney and his litigated instances. He thought we could. He mentioned specifically that you do have people that sort of troll the city for information from outside that just try to create burdens. So, you could fall back on FOIA. We always have FOIA as like, that's what you have to do. And if that's something that they're really trying to buck up city operations, but, if Diane comes in and asks me to see a copy of something and it's not the city clerk can walk 10 feet away, it's a copy of it. The goal should be to try to show them the document.
So how about if you write that up, what you're doing, and when Mark comes and he presents it, I don't know that we have our income tax presentation to that day. But at least we'll have something, we won't have Tony write something up just yet until we see that.
Diane probably has comment on this too. I actually asked Redmer to write it, told me to do it. I tried to push it back on him, separate. So, just to finish that, he's also said these other obligations and meetings, yeah, we may not be personally, so I just asked him to submit. I'll propose for us to look at.
And I think,
Yeah, we can discuss it now, it's actually right, so.
Just one quick comment on that, going back to where you started, which is addressing the problems, and with solutions. A lot of language in terms of documents that are repeatedly requested, making documents readily available. That puts a lot of discretion in the hands of the government officials.
Got a bird.
And I don't know that what you suggested would actually change the status quo too much, because if you say, documents that are readily or that are repeatedly requested have to be made available, in some other form, have to be published somewhere. Who defines what readily requested or repeatedly requested, right?
Well, he had an answer for that, as Black's law defines what it is, but more than 2 or 3 times.
Two or three, but
I had the same concern that Jonathan did.
He said there's no time limit on Wikipedia.
But so if I go and say, okay, I want a police report about this incident, and then the defendant goes, and I want a police report on this incident, it has to be on the website,
Or at the library.
No, the reason it's at the library is because it's all in Muni code and it's all published. So we're digitizing. I don't know what we're not digitizing, but our records are digitized. That's why it's easy as having a laptop that we can pull up the Muni code. And anybody can see that at City Hall or at the library. Get
I
logged
know
in.
Pam's gonna disagree with me on this. I think it's redundant to have some of the stuff at the library,
I'm-
especially if it was a paper.
The point, well, paper copies, paper. I'm not talking about any paper copies of anything,
Okay.
honestly. Okay, so this is my problem with this is there's FOIA. It is the floor of what we're legally required to provide. And it's a game of lawyers and it's a game of details and it's frequently used to sue the city. So there's an adversarial relationship around that. And what I would like to see us look at is public records. And as I looked around, public records contain information, minutes, files, accounts, any other documents that the government body is required to maintain and must be accessible to the public. So we decide what is going to be in our Muni code, what is going to be generally available. And those are as much as we could possibly put out. And then when there's specialty issues that FOIA, that isn't in there, then that should be kind of a unique situation. And that's going to be our court records are public records, aren't they?
Unless they're under seal.
Right, but then they're specialty under seal, so those are already all out there. So those are already public records. So you're
police
gonna,
reports, court records, police reports.
okay, so police reports, maybe we talk about, do we want police reports as public records? Do we, but that's what I'm saying, so that to me is what, we should look at a bigger picture, what should come under. Why, so what we have on our webpage, for the city's Freedom of Information Act, FOIA, requests for public records must be submitted online or in writing by mail, fax, or email. Public records, how about records not available? You know what I mean? So what it says to me is, if I think of all the meeting minutes and everything, the ordinances and all that as public records.
they're
So,
all available online.
right, and so I'm not gonna do a FOIA request for public records.
The public records are much.
I understand we're defining it.
Fine.
Right. So then shouldn't be the discussion maybe we're having is, should all police reports be considered public records and available online? If not, okay, but that's like by category. So we don't, we decide what do we determine as a public record. And so when Grevner wants something out of somebody's drawer, that should definitely be a FOIA request. And the hard copies of things, the marking on a pavement or something, take a digital image of it. These are exceptional litigation materials. These aren't general city work. And I want this to look like, if you want to know something from the city, ask us. And I don't mind saying, send us an email, but I also say, go to the library. The librarian can tell you where to find the meeting code. You know what I mean? So as much as possible, should be public, just out in the public, not a FOIA request, not a, and so because that FOIA is not really available to them. I mean, it is, and then our website does a good job of saying, oh, click on this form and submit it. But yeah, I just don't know. Public records should be the point, and then the private decisions of the legal, yeah.
I guess, I would say two things. One, since Grevner is a citizen of this community, it'd be helpful if he would write out the complicated things should be in the charter so that we can actually look at the language that he seems to think should be here. And then, and I presume we're going to get something like that, for the next meeting. But looking at the document we have in front of us, my question to you, and I wasn't here when you had this discussion previously, but what are we accomplishing with this?
Well, the goal of this,
Just a minute.
I can answer that. It doesn't have anything to do with anything.
All public meetings shall be subject to the Michigan Open Meetings Act. Yes, we don't need that in charter. That's the law. The accessibility to public records shall be governed by the Michigan Freedom of Information. We don't need that in the charter. That's the law. That's our already a requirement.
The reason that it was asked to be put in this is that chapter 8 was empty, wanted a place that a citizen could go and say, how do I get a public record? Where do I look for it? And so they would have one chapter that would just say, this is where the public records are.
I would say that the last place a citizen is going to go to look for
Right.
that information is the charter.
Right, well, how this starts.
So let me finish. And then the first sentence of this, the city shall be dedicated to transparency of its proceedings and records. That's like meetings.
Yeah.
And why is that in?
Because
It's, if you're going to have something in here, it should say, this is how we're going to do this. Not according to state law, because we're already required to do that. Is there something in this that we're adding to the community that needs to be in a charter?
well, the lawyer pulled this out because
Jill is next, okay, and John.
I think part of it was there was inconsistent language throughout the charter on where to find stuff. So the thought was get rid of all of those and replace it with this. And this is what the attorney came up with.
Okay.
So that was the concept. Now, whether we've achieved it, I don't know. But instead of fixing all these sections to have them say the same thing, get it out and have it in one spot.
Jill said it's spot on. This came from a couple meetings discussing this and trying to move all the references to things that were available. We're striking some of those to here. I agree with you, Mark, and that's why I said after the last meeting, I read this and I thought, well, this pretty much just doesn't really mean anything. The only thing maybe we did different was the second sentence just says, documents in the charter will be on the website. So that's the only new thing we did. So that was back to the big picture point, and get lost in some of the notes I had there was, how can we, let's outline a few things we can actually improve transparency on that. Improve citizen access to records and not too burdensome for the city, not too costly, and just, try to improve transparency. Put something real in there, and that doesn't have to be through FOIA. And we could mandate that certain things are, more accessible from FOIA allows. Right?
Yeah, for instance, that second sentence.
the original ordinance,
All right.
so
We're gonna fix that earlier
the original ordinance
provision.
was,
That earlier provision. We will fix that earlier provision that referred to the city attorney formal reports, but this second sentence could refer to that as being mandated by the charter.
so there are a number of documents articulated as being available to the public in the charter. So this was originally just to cover the documents that are identified in the charter and having a consistent location for their access.
Right.
So, and it was determined by the group that instead of having the wording in each of the locations of the documents in the charter, that there'd be a separate section that then took on a larger transparency and access state. So it became beyond the charter And that was Jeff's suggestion. And then very, I think wisely, if it is going to be like an overarching declaration of the city's claim of transparency and access, I couldn't agree more that it needs to be specific. But then it became that wording was because, okay, this is not just here's where the documents are. It is now, here is a bigger thing, which just has emerged.
One other point, because I think, Mark, you weren't here last time, was Robert, by the way. So I had brought up 530 Albert project, and at that time, I had been asking, and including I called Mr. Lee, I said it was very helpful at the time. Really, you know, how a public servant should he picked up the phone and talked to me. I really appreciated it. I was looking for if anyone had done any sort of financial assessment of what the different aspects of the deal would be for the city. Giving parking spaces away at a discount, tax, all of it. Did anyone analyze it? And nobody had. I couldn't get a call back from the finance department, but I talked to a few different other people, and everyone was sort of saying, call so-and-so. But anyway, at the end of the day, no document existed. Element, again, Mr. Dempsey prepared one that day, and it was put out like an hour or two before city council did it. And so what I was suggesting too is that, to me, that's also transparency. I'm using that specific example, but I think that could happen multiple times where this was suggested to me that maybe there's instances where people try not to create documents because then they're not good for anybody for you. So maybe there should be times where we're also requiring that certain things are done. And I suggested that when we're doing tax or doing finance or something like that some sort of economic analysis is done, and that's in writing, available to council, to available to the public within a certain amount of time so people can look at it. You know, information helps people make better decisions. But that's an example where it got done fast and it was released fast. It could have been a FOIA thing. You could have told me, go ahead and submit a FOIA request and you'll get it 3 weeks after the council. That would have done nobody good.
You probably would have been told, FOIA doesn't require us to create that.
So, oh, absolutely.
That's the other issue.
So that's another piece of this that I didn't include here, but that this is where I get your advice to think about for the next time we get to this. Should there be certain things like an economic, I don't know what you want to call it, an economic impact assessment, when something like tax subsidies are done, where a record is created. So you as a council member will get that at a time, think it through, be the public can get it too. But it's nice to have officials that will talk to you as a citizen, resident or whatever, and to give you information timely rather than going through the FOIA process. So I'm just getting back to the big picture. If we can make sure documents are available out the delays, and I think that's just better for everybody. So you function better when information shows to people. So
All right, so chapter 8 has some work. Jonathan, I'm going to take your comment and then I'm going to do a summary.
I just, back to what Mark said on the first sentence. I understand your point that it may not mean anything, but I really strongly disagree with that. I think that it really is meaningful to have a mission statement like that, you know, that the city shall be dedicated to the transparency of its proceedings and records. To have that kind of mission statement in the city's governing document is actually very important. So I just wanted to say that before we moved on to the topic.
I guess, I think we talked about this before. We should have a separate report with recommendations that are not part of the charter. And maybe some of these things go in there.
That's a good.
Yeah. Because we already have a couple on the list. But any of the things that you think desperately need to be done that don't fit in here should go to that separate report.
Yeah, and I can just say that, you know, to just one, you know, we would never, you know, we've approved tax increment financing for various projects. We always receive extensive financial documents with regard to that. That wasn't readily available to the public. Those documents are not, they're just public documents. They should be available at any particular time, especially while the project is working its way through the system. Because it isn't, you know, it doesn't undermine the project. Let people know that we're looking at a financial document that says, you know, I mean, people don't understand TIF anyway, so it will be helpful that the general public understands exactly what.
Wouldn't they show up in the minutes?
not necessarily, no.
Don't they show up in the attachments to the agenda for the minutes? Thanks.
Yeah, And eventually, basically, if it's happening in the downtown, it's gone through the entire DDA process.
Right.
Unfortunately, does.
DDA.
And so that those DDA documents, people don't know, think, hey, let's go to the DDA.
But they're there.
Information.
A resource librarian, right?
All right, so in closing, we're gonna stop here now, because we're at 9:12. When you look at the agenda, can we start with in the old business, 4.9, 410, and 411, those things first? So, because we're closer to getting those done, plus the other ones that we discussed then tonight. Because we did 13, we might not, we only have 13 and 14, elections is the other one. They should be, we shouldn't find a whole lot in 13, so we really only have one new business item, which is chapter 14. And then we'll go back over our chapter 11, the ones that we set aside today. And we're going to have the presentation. You're going to bring back something from bars. So we don't have to do anything. The county doesn't have to do anything on this chapter 8 for right now. And I know we asked you asked us time about what's the history of the records they're kept. And Granicus goes back to October 2nd, 2012, our video from that point on, October 2nd, 2012 to current. We have video on the website. Furthest back we have printed where the agenda packets are on there is 2009, the year 2009. They don't have anything beyond that yet. Mr. Bellman said that they're working on digitizing those older records over time. So right now, accessibility is really any agenda packet from 2009 forward you have access to. So with that, I think we've everything you've asked for has been brought forward, and we've got some work to do, but we're on target, which is kind of amazing. If I can have a motion to adjourn, I will be. Moved by Edison Johnson and second by Hank. All those in favor say aye. All those opposed, say. Thank you all.
Thank you.
Now you don't have